Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. Brexit, of course, continues to dominate the headlines, but the prospect of an agreed trade deal still appears slim. In October, Theresa May did send one clear message that Britain will not continue to give EU nationals preferential immigration treatment after Brexit, but that waivers of visa requirements may continue on a reciprocal basis with countries. In addition, the government has confirmed its commitment that the 3 million EU immigrants currently living in Britain can remain even if the UK leaves the EU bloc with no agreement in place. We've seen two cases in recent weeks that have looked at situations where a director may be personally liable for his or her actions. In Wesley v White, a director of an insolvent company mistakenly signed deeds terminating two of the company's contracts, mistakenly believing that he was novating the contracts. The liquidators made a claim against him that he had not fulfilled his duties under Section 172 of the Companies Act of 2006, which requires directors to consider several factors when making decisions on behalf of their company. The paramount consideration for the director of an insolvent company must be the interests of its creditors. Now, ultimately, the court decided that the director had not breached his duties, as he had always intended to do the right thing, although with hindsight should have sought legal advice. The second case concerns shareholder directors who chose to direct funding into a new company to complete a building project to deliberately avoid payment to the contractors that had been instructed by the former and now insolvent company. In this case, because of a deliberate conspiracy, the court held the directors personally liable. It's worth noting the new reporting requirements that will oblige large companies from 2019 to explain how they comply with Section 172. In the case of Hyder Consulting v AMEC, AMEC issued a letter of intent and LOI to Hyder to govern various projects. The LOI included a cap on Hyder's liability. Now, subsequently, AMEC sent Hyder an instruction for car park design works, stating that the works were to be carried out in accordance with the terms and conditions that we are currently working under. Hyder acknowledged the receipt of the LOI and wrote, noting that certain items still needed to be agreed for incorporation into the formal contract. Now, the formal contract never materialised. A claim was subsequently made alleging that the design works were defective, and then there was a disagreement about whether the LOI terms that included the liability cap applied. The Court of Appeal, overturning an earlier court decision, ruled that the LOI terms and therefore the liability cap were incorporated into the contract. Although Hyder had never formally accepted of the terms, it had not rejected any terms, nor had it provided any counter-proposal. In addition, by its conduct of starting to work, showed that the terms had been accepted. We have previously reported the case of the rogue Morrisons supermarket employee who deliberately leaked payroll data of 5,000 employees. The affected employees subsequently brought claims against Morrisons, arguing that it is liable for the actions of the rogue employee. Despite Morrisons being able to demonstrate some good data security controls and that the rogue employee leaked the data using his home computer on a Sunday, the Court of Appeal agreed with an earlier court decision that held Morrisons liable as there was a sufficient connection between the rogue activity and his employment. Now, this is a clearly worrying decision for businesses. It's ultimately difficult or even impossible to protect against all the risks of rogue employees. Insurance may be the answer, but cyber insurance is still in its infancy, and it's not yet clear how insurers will react to this decision. The Information Commissioner's Office has begun enforcement action against 34 organisations that have failed to pay their data protection fees. The fees were introduced recently but have been the subject of much confusion. Fees are calculated by reference to 3 tiers. Micro organisations must pay £40, small and medium organisations must pay £60, and large organisations pay £2,900. The Competition and Markets Authority, the CMA, launched an investigation earlier this year into concerns that celebrities do not properly declare when they have been paid or rewarded in any form to endorse goods or services. The Committee of Advertising Practice, CAP, and the CMA recently issued guidance to help influencers and brands stay on the right side of the rules. The guidance includes examples of labels that are and are not acceptable to inform consumers of paid-for advertisements. In July 2017, the Supreme Court abolished employment tribunal fees, and unsurprisingly, there has been a significant increase in claims. Single claim cases are up 165% to 10,996 compared with the same period in 2017 when the fees still applied, and multi-claim cases are up 344% to 42,700, although just one claim against a large airline accounts for 23,000 of those claims. The government has started consulting on mandatory ethnicity pay gap reporting. The consultation seeks views on the scope, method, challenges and benefits of ethnicity pay reporting. It seems clear that the reporting requirements will become law, and the consultation is more about how the requirements will be implemented. The Supreme Court has decided that a baker did not discriminate when it refused to bake a cake containing a message supportive of gay marriage. Whilst the bakery could not lawfully refuse to provide the customer with their products because he was a gay man or because he supported gay marriage, they were not obliged to supply a cake iced with a message with which they profoundly disagreed. If an employer has had employees transferred to it following a cheapy transfer, e.g. where the employer has taken over the operation of service and the employees have transferred, any changes to employment contracts of the transferring employees because of the transfer will usually be void. A recent Employment Appeal Tribunal case, an EAT decision, however, upheld the right of an employer to change the employment terms after a cheapy transfer. Now, this case concerned electricians who, after the transfer from Birmingham City Council to a private contractor, had their travel allowance removed. The contractor argued that it was no longer justifiable. It had first been provided in 1958 when there were many depots and the electricians had to spend much time travelling between the sites. But this was no longer the case. The EAT was therefore satisfied that the change was not because of the transfer, but because it related to an outdated policy. The Citizens Advice Bureau has launched a super complaint to the Competition and Markets Authority over its concerns that loyal customers who stay with their providers of certain products, such as household insurance or mobile phone contracts, often on default or rollover contracts, can end up paying significantly higher rates than new customers who are often enticed with more favourable offers and rewards. Super complaints can be made by a government-designated consumer group and, when made, require the regulator to publicly respond within 90 days to confirm if it believes that there is an issue. Where an issue is confirmed, the regulator must further set out what steps it intends to take. The Competition and Markets Authority has concluded market research on awareness of competition laws. This has produced some surprising results, including that only 50% of companies surveyed knew that price fixing is illegal. 23% did not know that discussing prices with competitors during bid processes was illegal. And over 25% did not know that dividing up and sharing customers with competitors was illegal. The study results are concerning as the penalties for competition law breaches are severe, with fines of 10% of global turnover and imprisonment in some cases. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact me or any of my colleagues at Radius Law. We'll be back in December with more of the month's key legal updates.